The Supreme Court appeared slanted Thursday to dismiss previous President Donald Trump's notable claim that he's immune from prosecution. But the judges may still constrain the charges he faces and delay his trial on race obstruction charges. The court could decide that the lower courts ought to examine whether resistance applies to Trump's activities, requires more examination by the lower courts. Sometime recently Trump can be attempted. That would likely make it outlandish for a trial to be finished before voters choose in November whether to return Trump to the White House. Trump had much more victory than numerous court watchers expected, said John Yoo, a previous equity office official beneath George W. Bush. Only the three generous judges appeared to dismiss the thought of resistance outright. In the event that Trump becomes president, he may arrange the equity office to expel the charges against him. Here are the takeaways from the court's more than 2.5 hours of talkabout. Trump's attorney concurs a few affirmed acts can be indicted. It was a traditionalist equity and one of Trump's 3 chosen people on the court who looked for ways for Trump's trial to continue. Equity Amy Coney Barrett, to begin with, got Trump's lawyer to concur that there's no insusceptibility for a president's private activities, as restricted to those taken in his official capacity as president. Perusing from the prosecution, Barrett at that point inquired John Sauer if a few of the charges against Trump included as it were private conduct. What approximately contriving with a private lawyer to record untrue charges or to utilizing another lawyer to spread claims around race extortion he knew were false, she inquired. Sauer debated the characterization of the charges, but said that on the off chance that genuine, they cover private activities. When it was the equity department's turn at the seat, Barrett inquired Michael Dreeben almost the plausibility of the extraordinary direct attempting Trump fare on the charges that undisputable incorporate as it were private activities. The Uncommon Guide has communicated a few concern for speed and needing to move forward, she said. Is another alternative for the Uncommon advise to fare continue based on the private conduct and drop the official conduct. Dreeben said the two are interrelated since the steps Trump took as president made his other activities more likely to succeed. We would like to display that as in coordinates picture to the jury so that it sees the grouping and the gravity of the conduct and why each step occurred, he said. Wrangle about over how quickly trial may continue. Since indeed Trump's lawyer concurred that the previous president isn't resistant from arraignment from a few of the charges, the enormous address is whether the preeminent court will coordinate the lower court to require extra activity sometime recently seating a jury. That will decide whether a trial can start sometime recently, the November decision. Chief Equity John Roberts inquired Sauer what ought to happen in case the incomparable court hooks onto his concession that private acts can be indicted. Sauer said the locale court ought to decide which charges meet that definition sometime recently Trump can be attempted. Equity Sonia Sotomayor supported the equity department's position that the locale court judge can choose those issues as the trial unfurls. So I'm not beyond any doubt that I get it why your issues couldn't be taken care of at trial with an instruction in case we accept. On the off chance that the court were to discover, I'm not indeed beyond any doubt how they might. But in case it were to discover that a few public acts might not be the premise of criminal risk, she told Sauer. Rick Hasen, an election law master at the UCLA School of Law, predicts the court's choice will be closer the government's position than it'll be to Trump's clearing resistance contention. But the judges are likely to discover different ways of getting there, which suggests the conclusion will take longer to compose, and a lion's share will need encourage procedures. The bottom line is that Trump is likely to induce what he needs. Advanced delay of this decision subversion case, maybe pushing it to after the election, Hasen composed. Judges resuscitate wrangle about almost presidents murdering political rivals with resistance. When Sauer contended for Trump at the D.C. Circuit Court of Offers, Judge Florence Dish squeezed him on whether a president might arrange SEAL Group 6 to murder his adversary and be resistant from indictment unless arraigned and sentenced. Sauer said the speculative president seemed as it were be arraigned after he was arraigned and sentenced in Congress. Equity Samuel Alito said he didn't need to criticize SEAL Group 6 since its individuals are honorable and are bound beneath the Uniform Code of Military Equity not to comply illegal orders. I'm beyond any doubt you've thought of lots of hypotheticals where a president seems say, I'm utilizing an official power, and however the president employments it in an absolutely preposterous manner, Alito said. Sauer attempted to direct the discussion absent from what the immunity would cover. But Equity Alina Kagan inquired whether it may well be an official act for a president to order a military upset. It's an official act, but that beyond any doubt sounds awful, doesn't it? Kagan inquired. Sauer said it sounded awful, but that the composers of the structure put checks input, such as arraignment, to avoid something like that from happening. Well, it certainly sounds exceptionally awful. And that's why the composers have an entirety arrangement of auxiliary checks that have effectively for the final 234 a long time avoided that exceptionally kind of extraordinary hypothetical, Sauer said. Judges address whether presidents can acquit themselves. No president has, however, exculpated himself, and not one or the other, the courts nor the Equity Division, have issued suppositions on whether it's conceivable. But the danger of criminal charges approaching over previous presidents after the takeoff office is why Trump fights presidents must be safe from arraignment for their official acts. Equity Neil Gorsuch raised the issue of whether presidents can pardon themselves since it fears a successor seen charge them criminally. He proposed presidents might exculpate themselves every 4 years to dodge the danger. It seems to me like one of the motivating forces that can be created is for presidents to undertake to exculpate themselves, Gorsuch said. We've never replied whether a president can do that. Joyfully, it's never been displayed to us. Sauer, Trump's lawyer, said in case the court rules presidents have insusceptibility, judges wouldn't ought to stress almost whether presidents seem pardon themselves. The legitimateness of that has never been addressed, Sauer said of self-pardons. Alito said the court must know the Equity Department's position on whether presidents may acquit themselves, since on the off chance that there's no insusceptibility, won't the unsurprising result be that presidents within the final couple of days of office will acquit themselves from anything they might have been conceivably charged with committing? Dreeben, counselor to Equity Office, Uncommon Guide Jack Smith, said the department hasn't taken a position on whether a president might exculpate himself, in spite of the fact that a part of the Office of Lawful Counsel wrote that there's no self-pardon authority. Dreeben said the issue has, as it were, emerged within the case of Richard Nixon, who was pardoned by his successor after the Watergate embarrassment, and in Trump's case. But he said a self-pardon would violate a bedrock principle that individuals shouldn't judge themselves. Preeminent court, writing a run the show for the ages in Trump case. The judges sounded quite aware of choosing the notable case. Trump is the primary previous president ever to confront criminal charges. Potential resistance from charges isn't composed into the structure, and the tall court has never ruled on what insusceptibility the president might appreciate.